The plaintiff, William Mitchell III, commonly known as Billy Mitchell, lives in Florida, United States of America. He has been well known among adherents of video and arcade gaming in many countries, including Australia, since 1982. At an arcade and video gaming competition in November that year that took place in Ottumwa, Iowa, USA, playing an arcade game called Donkey Kong, Mr. Mitchell scored a world record 874,300 points and was the first person ever recorded as reaching the kill screen, that is, reaching the end of the game. At the time, he was 17 years of age. Mr. Mitchell went on to be recognized as having achieved a number of world records and world firsts in video and arcade gaming. They included achieving the first perfect score of 3,333,360 in another game called Pac-Man in 1999, setting a new world record and the first score of over 1 million points, the record being 1,047,200 points in Donkey Kong in June 2005, another Donkey Kong world record of 1,050,200 points in July 2007, and a third Donkey Kong world record of 1,062,800 points in July 2010. Those records were recognized by such bodies as Guinness World Records and Twin Galaxies, which is an American company that organizes gaming competitions and keeps a database of records and rankings across various gaming platforms. In 2017, Mr. Mitchell was accused of having cheated in achieving his Donkey Kong world records by allegedly using computer emulation software instead of original arcade hardware. Twin Galaxies investigated the accusation, and in April 2018, it announced that it had concluded that 2 of Mr. Mitchell's world record scores were not produced by the direct feed output of an original unmodified Donkey Kong arcade printed circuit board, or PCB. It was not able to determine whether the third score was produced on original arcade gaming hardware or with the use of emulation software. As a consequence of its findings, it announced that it had decided to remove all of Mr. Mitchell's scores and to ban him from participating in its competitive leaderboards. The following day, Guinness World Records announced that as a consequence of Twin Galaxies' decision, it too had disqualified Mr. Mitchell as the holder of all his records, both in Donkey Kong and in Pac-Man. Mr. Mitchell commenced proceedings in the United States for defamation against Twin Galaxies and a number of others. One of those lawsuits was against a young man, Benjamin Smith, who was known online as Apollo Legend. I refer to him as Apollo Legend in my reasons. He published videos on YouTube about gaming, including a number in which he accused Mr. Mitchell of cheating, falsifying his Donkey Kong scores, and not using legitimate gaming hardware. Mr. Mitchell and Apollo Legend settled that proceeding on 22 August 2020. Their agreement relevantly provided that Apollo Legend would remove all of his YouTube videos and social media posts that referred to Mr. Mitchell. He would assign the copyright in those YouTube videos to Mr. Mitchell, and he would permanently cease producing any oral, written, or electronic documents or communications that in any way mentioned or referred to Mr. Mitchell or his family, apart from making an agreed statement in terms provided in the settlement agreement. Any breach by Apollo Legend of the last of these obligations would result in him being liable to Mr. Mitchell for $25,000 for each breach. Unless he committed such a breach, he did not have to pay Mr. Mitchell any money. Apollo Legend appears to have complied with that agreement. However, on 20 December 2020, he published a video on YouTube, referred to in this proceeding as his goodbye video, in which he told viewers that he was recording his final video. He said, "This is the end of my life," and he explained why. In that video, he did not mention Mr. Mitchell, nor the claim against him or the settlement agreement. Shortly after publishing it, he committed suicide. The defendant, Karl Jobst, lives in Queensland. He regularly publishes videos on YouTube, mostly about speedrunning, but also about video and arcade gaming world records and people who cheat in those games. He has over 1 million followers on his YouTube channel. On 26 May 2021, he published a video about Mr. Mitchell and another video gamer, Todd Rogers, entitled "The Biggest Conmen in Video Game History Strike Again." He accused Mr. Mitchell and Mr. Rogers of cheating and of pursuing unmeritorious litigation against people who had accused them of cheating. He also said the following about Mr. Mitchell, quote, He also sued YouTuber Apollo Legend for $1 million. I haven't spoken about this publicly, but this lawsuit ultimately ended with Apollo giving in and settling with Mitchell. He was forced to remove all his videos about Mitchell's cheating and paid him a large sum of money. This left him deeply in debt, which required him to find extra work, but with his ongoing health issues, this was all too much of a burden, and he ultimately took his own life. Not that Billy Mitchell would ever care, though. In fact, when Billy Mitchell thought Apollo died earlier, he expressed joy at the thought. The lawsuit against Apollo was just as frivolous as the rest, and Apollo definitely would have won in court. But again, he was extremely ill and couldn't handle the ongoing stress. End quote. That video containing that passage was online for 10 days from 26 May 2021 to 4 June 2021, and for an additional 5 days from 9 June to 13 June 2021. In between those dates, and since 13 June 2021, the video has remained online, but it contains only the first 2 sentences and the last sentence of the passage that I have just read. While the video was first online in its full version, 2 relevant events occurred. First, on 3 June 2021, Mr. Mitchell published his own YouTube video in response to Mr. Jobst's video. He denied as lies the assertion that Apollo Legend had paid him any money as part of the settlement, or that he had had any involvement with Apollo Legend that had led him to commit suicide. He asserted that Mr. Jobst had effectively accused him of murder. He ended the video by saying, quote, "I plan to respond the way that everybody anticipates for me to respond. And Karl, expect me." End quote. The second relevant event is that a mutual acquaintance of Mr. Mitchell and Mr. Jobst, known online as Keemstar, contacted Mr. Jobst at Mr. Mitchell's request and told him that it was not true that Apollo Legend had paid Mr. Mitchell any money. Mr. Jobst agreed to take down that part of the video while he investigated that issue further. While not taking it all down, he only left up the first and last sentences of the passage that I have read. He then emailed Apollo Legend's brother to ask him whether Apollo Legend had to pay any money to Mr. Mitchell as part of the settlement. Mr. Mitchell's lawyers then served a concerns notice on Mr. Jobst, asserting that he had defamed Mr. Mitchell. In response, Mr. Jobst posted that letter on Twitter, claiming it to be very exciting and that any action would be an amazing experience. He then reinstated the original version of the video on his YouTube channel. It was not until 13 June 2021 that Apollo Legend's brother informed Mr. Jobst that Apollo Legend had not paid any money to Mr. Mitchell. Mr. Jobst then altered the video again to remove all except the first 2 and the last sentences. That version has remained on his YouTube channel since then. The video containing all of the offending passage was downloaded in the periods that it was online by over 500,000 people, including over 20,000 in Australia. Since then, over 8,000 comments have been made on the video, including at least 396 that, it may be said, accused Mr. Mitchell of causing Apollo Legend to commit suicide and even called him a murderer, evil, and a scumbag. Similar comments have also been made on videos by other publishers on YouTube or other online media. The most recent that has been brought to my attention having been made in early 2024. In this action, Mr. Mitchell sues Mr. Jobst for defamation, claiming $400,000 in general damages and $50,000 in aggravated damages. Mr. Mitchell contends that the video, particularly the passage that I have read, made 5 defamatory imputations about him. Those imputations were, first, Mr. Mitchell had required Apollo Legend to pay him a large amount of money to settle Mr. Mitchell's defamation claim against him, which caused Apollo Legend to go into considerable debt and to take on extra work to survive. Secondly, a major contributing factor in Apollo Legend's decision to take his own life was Mr. Mitchell's requirement that Apollo Legend pay him a large sum of money to settle the defamation claim. Third, Mr. Mitchell had hounded Apollo Legend to death. Fourth, Mr. Mitchell was the main cause, or alternatively a cause, of Apollo Legend taking his own life. And fifth, Mr. Mitchell's conduct was a contributing factor in Apollo Legend taking his own life. Mr. Jobst denied that the imputations alleged by Mr. Mitchell were made in the video. I have found that the video made each of those defamatory imputations. Mr. Jobst also defended the claim on a number of other grounds. First, he alleged that Mr. Mitchell had a pre-existing bad reputation that meant that any of the defamatory imputations alleged would not have harmed him. That reputation, Mr. Jobst alleged, was threefold. First, Mr. Mitchell had cheated to gain recognition as the highest or one of the highest scorers in Donkey Kong. Secondly, he had used litigation processes to coerce others to recognize him as a world record holder in Donkey Kong and to refrain from identifying him as a person who had been found to have cheated at video arcade games. And third, that he would ostracize anyone he considered a threat to his world records in Donkey Kong. As to his alleged pre-existing bad reputation, I have found that Mr. Mitchell did have a reputation as a cheat in Donkey Kong and a reputation for suing people who alleged that he was a cheat. I have found that he did not have a reputation for ostracizing anyone he considered a threat to his achievements. Mr. Jobst's other principal defense was that the video made 5 other defamatory imputations, each of which was substantially true, and as a result of which, the imputations about which Mr. Mitchell complains did not cause any greater harm to him or his reputation. Those imputations, which are referred to in defamation law in Queensland as contextual imputations, were, first, Mr. Mitchell was publicly exposed as having cheated to achieve his record scores in Donkey Kong. Second, Mr. Mitchell was banned from submitting scores to Twin Galaxies for cheating. Third, Mr. Mitchell had planned to create a video that he could use fraudulently as evidence that he had achieved the score of 1,062,800 in Donkey Kong. Fourth, Mr. Mitchell had callously expressed joy at the thought of Apollo Legend's death. And fifth, Mr. Mitchell used litigation to force third parties to recognize his achievements in video gaming. I have found that all of those contextual imputations were made in the video. All but one of them were substantially true. It was not true that he had planned to produce a fraudulent video. To be clear, I was not required to decide, nor did I decide, whether Mr. Mitchell had in fact cheated in gaining any of his world record scores. Mr. Jobst did not attempt to prove that that finding by Twin Galaxies was correct. Notwithstanding these findings, I have concluded that the defamatory imputations made by Mr. Jobst, that are the subject of Mr. Mitchell's claim, have caused substantial additional damage to Mr. Mitchell's reputation and have caused him considerable additional distress. Therefore, Mr. Jobst is liable to pay damages to Mr. Mitchell for those defamatory imputations. I shall come shortly to the amount of those damages. Mr. Mitchell also asserted that Mr. Jobst's conduct in publishing the video, and after doing so, was unjustifiable and caused additional personal hurt to Mr. Mitchell and harm to his reputation, which justifies the court awarding additional damages known as aggravated damages. This conduct, alleged by Mr. Mitchell, included, first, making the allegations recklessly and without checking their truth. Secondly, publishing the video twice. Thirdly, holding malice and pursuing a vendetta against Mr. Mitchell. Fourthly, mocking Mr. Mitchell's complaint about the video and his legal action. Fifthly, persisting in his contention that Mr. Mitchell's action against Apollo Legend had contributed to his decision to commit suicide. And sixthly, failing to apologize and to withdraw the allegation. I have found that Mr. Jobst was reckless in making the allegations. His assertions were based on a fallacy, namely that Apollo Legend had paid Mr. Mitchell a large sum of money. That was simply wrong, and he had no reasonable basis for asserting it. Yet even after finding out the truth, he has continued to assert that the settlement had a negative financial impact on Apollo Legend, and that he still believes that the settlement was a contributing factor to his decision to commit suicide. Mr. Jobst was also reckless and vindictive in publishing the full video twice. At the time he republished it, he had been told by Mr. Mitchell, via his response video, by their mutual acquaintance Keemstar, and by Mr. Mitchell's lawyers, that what he had said about the payment was not true. He told Keemstar that he would not republish that part of the video unless he received concrete evidence that it was true. But by the time he republished it, he had not heard from Apollo Legend's brother, whom he had asked for information about the settlement, so he did not know any more than he had earlier, but he nevertheless decided to republish the entire video regardless. In his evidence, he said that he did this because he thought Mr. Mitchell would sue him anyway. His attitude appears to have been, well, if I'm going to be sued, I may as well go for broke and damn the consequences. It was reckless, and showed an absolute disregard for the truth or for the effect of his video on Mr. Mitchell and his reputation. On 29 July 2021, that is about 6 weeks after he finally edited the video and took out the offending passage, Mr. Jobst published a video in which he retracted his statement that Apollo Legend had paid Mr. Mitchell money, and he apologized to his viewers for having given them incorrect information. At the trial, he relied on that video as being evidence of his bona fides and as reducing any harm caused to Mr. Mitchell by his original video. However, that video did not retract the imputations at all. It simply retracted the statement that Apollo Legend had paid Mr. Mitchell a large sum of money. Mr. Jobst did not apologize to Mr. Mitchell in any way, rather apologizing to his viewers for having made an incorrect statement in the offending video. Also, this retraction video was, in total, a little over 30 minutes long. For the first 28 minutes and 24 seconds, it had nothing to do with arcade gaming, cheating, or Mr. Mitchell. It was about a particular type of speedrunning. It then went blank for a few seconds before it returned with Mr. Jobst's alleged retraction statement, which itself lasted only about 45 seconds. Even then, he wrongly said that Mr. Mitchell had not tried to contact him to clear up the error, and he insinuated that he still believed that Mr. Mitchell was responsible for Apollo Legend's decision. Finally, Mr. Jobst's conduct of this litigation, together with his additional online comments about it, were aggravating features of his conduct. He seems to see himself in defending this claim as a crusader against Mr. Mitchell. He is the last of the defendants who have been sued by Mr. Mitchell, and the only one, apart from Mr. Race, who has not backed down. Even in February 2024, as this action was progressing toward trial, he said in an online interview, quote, "Billy Mitchell needs to be destroyed in court. These people need to be punished in a big way before they stop. They need to get taught a lesson. So I am now the last chance. I am the last chance the public has to punish Billy. And also, the last person on YouTube you want to lose to is me. You know there's going to be 100 vids rubbing it in. I will never let Billy forget this, assuming I win. I've got to win first, but man, if I win, oh boy, I'm not going to be a good winner." End quote. Mr. Jobst clearly intended to be the knight who slew the Mitchell dragon. Unfortunately for him, his lance was not as strong as he believed it to be, and it has broken in the contest. I have found that all of this conduct has caused Mr. Mitchell additional personal harm and additional harm to his reputation. It was severely aggravating conduct that merits an award of aggravated damages. Again, I will come shortly to the amount of aggravated damages that I will award. I was asked by each party to make adverse findings about the truthfulness of the other party's witnesses and the reliability or otherwise of their evidence. In my full reasons, I have given detailed consideration to those submissions. I don't propose to reprise that discussion and my conclusions now. Having made these findings, I consider that Mr. Mitchell is entitled to an award of damages against Mr. Jobst. I have considered other comparative cases in order to help me to decide the appropriate amount. Under the Defamation Act of Queensland, the maximum amount of damages for non-economic loss, that is, general damages, not including any aggravated damages, is currently $478,500. That amount can only be awarded in the most serious case. In addition, though, in appropriate cases, additional aggravated damages can be awarded, and there is no statutory limit on aggravated damages. Mr. Jobst contended that for a number of reasons, any damages I award should be minimal, or at least reduced, due to two mitigating factors. One of those factors was that he published the so-called retraction video. For the reasons I've already mentioned about that video, I do not consider that it had any mitigatory effect. Rather, publishing the retraction at the time and in the manner he did was an aggravating feature of his conduct. He did not publish it in a way that would draw it to the attention of the original audience, but instead essentially hid it from view. And of course, he did not retract any of the imputations against Mr. Mitchell, nor apologize to him. The second reason he gave for mitigation of damages was that Mr. Mitchell, he said, has contributed substantially to the harm he has suffered because he put the offending part of Mr. Jobst's video into his response video, saying, quote, "For those of you who haven't seen it, here's the clip," end quote. Mr. Mitchell's video showing that clip has remained online ever since. It has been downloaded at least 155,000 times. As I say in my reasons, This submission might be described as suggesting that Mr. Mitchell called in an airstrike on his own position. I disagree, both by making the response video and by bringing this proceeding against Mr. Jobst. Far from calling in an airstrike on his own position, it was necessary for Mr. Mitchell and reasonable for Mr. Mitchell to identify the enemy's position clearly in order to call in an airstrike on it. That is what he has done. He made clear in his response video that he denied the imputations made by Mr. Jobst and that what Mr. Jobst had said was false. His conduct in publishing this video was reasonable and it does not justify any reduction in the amount of damages. Factors particularly relevant in determining the appropriate amount of damages include the number and seriousness of the defamatory imputations, the extent of their publication, the effects they have had on the plaintiff personally and on his reputation, and what is known as the grapevine effect. The grapevine effect is the likelihood that the defamatory imputations have been and will be repeated to other people over time, and they may even surface again after this judgment. The grapevine effect arises particularly in cases of defamatory imputations made on social media or other internet sites, including YouTube. In this case, there is ample evidence of the extent of the grapevine effect. It has been very extensive. The evidence is the number of comments on Mr. Jobst's video and also comments made on another online personality's videos about Mr. Mitchell, which even recently included assertions that Mr. Mitchell had caused or contributed to Apollo Legends' suicide. Coming to the amount of damages that I will award, Mr. Mitchell seeks $400,000 in general damages, that is, damages for non-economic loss, as it is described in the Defamation Act. In my view, that is too high, being too close to the maximum permissible amount. This is not one of the most serious cases, although it is at the higher end, especially given the most damaging imputation that Mr. Mitchell hounded Apollo Legend to death and the extent of publication. Mr. Mitchell's aggravating conduct has been serious and ongoing, including in his evidence at trial and in his publications about this litigation. It merits substantial aggravated damages, and Mr. Mitchell asked for $50,000 in aggravated damages. I have concluded that there should be judgment for Mr. Mitchell in the sum of $300,000 for non-economic loss and $50,000 in aggravated damages. As I say in my reasons, he may well have been justified in being ordered to pay more than $50,000 in aggravated damages, but that is the amount sought by Mr. Mitchell, and that is the amount I shall award. In addition, Mr. Jobst should pay interest on those amounts. Unless I receive submissions for some other order as to interest, it seems to me, from other cases, that the appropriate rate and period of interest will be 3% per annum from the first date of publication to today. That amounts to a total of $40,446.58. Finally, ordinarily an unsuccessful party is ordered to pay the successful party's costs of the proceeding. At present, I see no reason why I should not make such an order against Mr. Jobst. However, I shall give the parties an opportunity to seek an alternative costs order, either now or by written submissions to be provided within 14 days, but preferably now. The judgment of the court is therefore 1. Judgment for the plaintiff for damages for non-economic loss in the sum of $300,000 plus interest, subject to either party seeking a different order as to interest upon delivery of this judgment or by filing and serving a written submission within 14 days, of $34,668.50. Judgment also for aggravated damages in the sum of $50,000, plus interest of $5,778.08, subject to either party seeking a different order as to interest upon delivery of this judgment or by filing and serving a written submission within 14 days. 2. Unless either party seeks a different order as to costs, either upon delivery of this judgment or by filing and serving a written submission within 14 days, the defendant pay the plaintiff's costs of this proceeding. I published my reasons together with a short summary of those reasons. Both documents will be publicly available shortly on the Queensland Court's website. Are there any submissions on questions of interest and costs?